Okay. For those of you who just joined, I'm Sue Ostoff with the National Clearinghouse for the Defense of Battered Women, and I really want to welcome all of you, and thank you for joining us. This webinar is the 13th in our series of webinars about expert witnesses in cases that involve survivors of battering, sexual assault, and other forms of trauma. And if you missed any of the earlier webinars in this series, the recordings that pull up the copies of the PowerPoint, once you start listening to it, are posted on our website at ncdbw.org. So you can go and find the recordings there. As you've probably noticed, all the participants are muted, and as I mentioned earlier, we will collect questions during the presentation, and time allowing, we will ask our presenters as many as we can at the end of their presentation, and they're planning to leave about 15 minutes for questions. Before I go further, I want to just take a second to thank the Office on Violence Against Women for the support of this project on expert witnesses. And we just think it's great that they are supporting this work about expert witnessing, and so many, many thanks to Office on Violence Against Women. So as you're probably aware, today's webinar is titled Domestic Violence Expert Witnesses in Civil Legal Proceedings. And now I'm going to hand this over to my coworker, Kirsten Facel. She's our legal coordinator here at the National Clearinghouse for the Defense of Battered Women, and she's the lead staff person on our Expert Witness project. So she's going to go ahead and introduce the speakers and let you know a little bit about the format for today's webinar. Thank you.
Thank you, Sue. Good afternoon, everybody. It is my privilege to introduce our two wonderful presenters for today. We have Margaret Bassett from Texas with us. She has worked in the field of domestic violence for 30 years, and she's done that in many different capacities. She's worked in the criminal justice system with victims of felony intimate partner violence crimes. She's been a counselor and manager in many different shelters and resource centers, and she's participated in community collaborations and was a member of the Safe Place Risk Management Team. She also teaches at the University of Texas and is the director of their Expert Witness program in the School of Social Work at University of Texas. She provides expert witness testimony, and she has been doing that since 2008. Our other presenter, who, if you have been participating in these webinars for a long time, you've had the privilege of hearing before, is Kirsten Facel, who has been the Director of Training and Technical Assistance for the Iowa Coalition Against Domestic Violence for about 20 years. At the Coalition, she works on developing public policy and provides professional support to agencies that impact battered women and their children. She's also on the steering committee for the Batters Education Program for the Iowa Department of Corrections. She provides training for law enforcement and for the Department of Human Services, and she heads up the Iowa Domestic Abuse Death Review Team. She's also been providing expert testimony in both civil and criminal cases for several years. So both of these fine women have a lot to share with you today, and I'm very excited that they're here to do that. Before we get into hearing from them, though, I just want to explain just for a second about how we ended up deciding to do this particular webinar. I see from the chat box that there's a lot of experienced experts on this training, which is great, and a lot of people have varied experiences in civil cases, in immigration cases, in criminal cases, etc. But it's been our experience that at least as far as community-based advocates go, they may have experience testifying in criminal cases on behalf of the prosecution, and maybe they don't have that kind of experience in civil court. So we really wanted to focus on ways that expert testimony can look in the civil context. And our main audience here really is a focus on community-based advocates. I think it'll be helpful for everybody, no matter what your professional background is. But this was definitely designed with advocates in mind, particularly those who are new to the idea of providing expert testimony. So I want to just start with asking our presenters, Margaret, can you just talk a little bit about the kinds of cases in which expert testimony about domestic violence and sexual assault might be needed, and what are the kinds of cases that you tend to get phone calls about?
Sure. So some of the more common cases are going to be child custody or divorce cases, cases that are involved with child protective services, possibly parental termination cases, immigration cases, whether from a domestic violence or sexual assault that occurred in the United States, or if someone is fleeing their home country because of domestic violence or sexual assault. They can testify, an expert witness can testify in tort cases. The tort case would involve some sort of negligence or an intentional wrong that caused harm. So you can see how an expert might be able to address some issues in that and be helpful. And for myself, I've most typically been asked to testify in child custody or divorce cases and immigration cases. We're really fortunate that we have a strong protective order division here in Austin, Travis County, and our judge is pretty well educated on the dynamics of domestic violence. And then throughout my career, I've been useful as a, I'm going to say, advocate/expert with the housing authority or with crime victims compensation or employers on behalf of survivors.
Kirsten, did you want to add anything?
Yeah, I would say that, again, very similar. Overwhelmingly, I've been asked to assist with custody cases, and then also child termination of parental rights cases, also lots of stuff dealing with kids. And then after that, probably immigration cases, and also with the issues around housing and maybe not a civil court case, but I think if we just lump in all kinds of administrative hearings, which have the same kind of things going on as what we're going to talk about, housing stuff, disability benefit claims, Margaret, you mentioned employment, college disciplinary hearings, you name it. There are all kinds of kind of quasi-legal proceedings that could benefit from having that DV knowledge, really, as a context for folks that are making the decisions who often know very little, think they know, but actually, in fact, know very little about domestic violence.
Thank you. Kirsten, can you talk about how you decide whether or not you're going to take a case, like what information do you need, if any, and who you need to talk to and who you don't, and that kind of thing?
Sure. Actually, one of the very first questions I ask when somebody calls is, do you have a hearing date and when is it? And one, it's simply about schedule. But two, what that tells me is if it's tomorrow or it's next week, that tells me that I'm an afterthought, and I am much more likely to not take that case simply because I'm not confident that my testimony would be used as effectively. If I'm just being thrown in there to just spatter and see what sticks, I'm going to be a lot more hesitant. So partly it's a scheduling thing, but also it's kind of just lets me know where the attorney's at in approaching using expert testimony, and what kind of experience or relationship that's going to be from the start. So I want to know, when is a case, how much time do I have ahead of time to prepare, because there's really two schools of thought with pros and cons before, and other webinars have talked about this. There's the idea of going in completely as a blank slate and not knowing anything about the case, so that there's no accusations of bias, etc. I like to go in knowing as much as I can about the case, so I do like to have more prep time. I want to know for myself if there's actually domestic violence, because there's been times when I've looked at case materials and said, well, you do have bad behavior, but what you don't have is fear. You don't have that component of coercion. You have somebody or maybe two parties who are not anybody that I would personally want to be partnered to, but it really doesn't rise to the level of abuse and certainly the kind of intimate partner terrorism that we deal with day to day. So I want to take a look at to see, is there domestic violence, and then I also want to, am I the right person? Is there anything I can contribute? Would somebody else be better? Does the attorney want me? Sometimes I get cases where the attorney says, well, my client told me that I was supposed to call you, and I'm not really sure why or what on earth you could do to help this case. That conversation, there's a good chance I'm probably not going to take that case, because if the attorney doesn't think there's any point, there's no way that I'm going to beg to be led onto a case to participate. So I want to know where the attorney's at. I want to know how much lead time. I want to know, is there domestic violence? And I want to know, is there anything that I can actually contribute to the case? And as far as meeting or contact, I want as little contact with the actual parties as possible.
Margaret?
Yeah, Kirsten, I really like what you said about being asked last minute. I think that's a really good point, because it is the attorney, the requesting attorney. In working with the requesting attorney, you have to know either they know what they're doing or they're open to learning about how expert witness testimony could be helpful. And so when it's a last minute situation, that really does give you a good indication about their preparedness around the case and around the issue of domestic violence. Generally, so I think Kirsten really covered everything very well. I tend to talk with anybody who calls me just because I want to educate the world if I can. So I will talk with whoever calls and try to clarify what's the tough case fact or facts that they think an expert would be helpful in addressing, or what needs shoring up. And then from there, we kind of talk about what are they, so what are the tough case facts, how can an expert witness address those, and then is that something that is actually a part of the current proceeding. I don't usually meet with clients in custody or divorce cases. With immigration cases, I do meet with them, and I will read everything that the immigration attorney has. The other thing, if there are police reports at all, I try to look at those, and part of that is just in terms of risk assessment and safety issues.
So that's where seeing yourself as an advocate and an expert, as you mentioned before, that kind of speaks to that, right?
Yeah, absolutely.
Kirsten, you mentioned when you were discussing this that you pay a lot of attention to whether you think you're the right expert. Can you give an example of a case or some cases in which you didn't think your expertise was on point for that particular case?
One that comes to mind is that even though there was some domestic abuse, it really seemed to me that somebody with expertise in the area of adult survivors of sexual abuse would have been much more on point and would have been able to have more credibility speaking to what I saw. And that was a piece of educating the attorney as really the more pertinent issues. That one seemed pretty clear. There's other times where it's like, you don't need me. You need a psychologist. You need somebody licensed who can simply diagnose this person and say, yes, they have PTSD, and I can't do that. So that's a real common one. Mm-hmm. They're looking for a diagnosis rather than general context.
Margaret, how about you?
Yeah, I can. The first one that comes to mind is in immigration cases. If in the case it seems like they actually need a country-specific expert in addition to domestic violence, I will encourage them to try and find someone who can combine both of those. And I'm trying to think, there's times where even domestic violence might be a part of the relationship, but what is actually happening in the court, what's being settled in the case, doesn't really tie into the domestic violence. And I've only had a few of those where I just said I didn't think that my testimony, it seemed like my testimony would open a can of worms that wasn't really a part of what was happening in the court, and my concern was that it would backfire, that it would just backfire and hurt the client.
And has it been your experience that attorneys are receptive to that kind of feedback about what you believe the impact of your testimony is going to be?
You know, interestingly enough, I have not had issues with civil attorneys being receptive and open to feedback.
Good. I prepared a bunch of questions in advance to talk with Kirsten and Margaret about, and I'm just kind of thinking my eyes were bigger than my stomach here, so there's a couple of things I'm not going to be able to get to, but I would really want to know from either of you, do you know, in your communities, do you see civil cases happening that you really wish more people were calling you about, or that more people were using expert services for?
Kirsten, you want to take that one, or I can?
Sure, absolutely. As I mentioned before, when I think civil cases, my mind immediately just goes to custody and protective order, and it doesn't go to all of those other places that, you know, when I think about what kind of an impact court systems and legal systems in general have on survivors' lives, I would actually argue that the criminal justice system has the least impact in terms of safety and changing their lives. But all those other systems, custody, child welfare, so those things, that's about my everyday, day-to-day life. So this housing hearing where I'm saying, please don't throw me out of my home, probably has a more tremendous impact, and that's actually where I wish we were spending a lot more of our time, is in those kinds of hearings. You know, do I get my disability benefits? Can I please have my VAWA visa so that I can stay here? I wish that we were doing more, that we had more resources to do more in those areas.
And Kirsten, can you, just to follow up on that, can you give an example of what an expert might do in a, you know, if a survivor had a hearing with the housing authority?
Well, yeah. For example, there are many places, and Iowa, unfortunately, is one of those, where if you call law enforcement too many times, you're at risk of being thrown out as being a problem and disruptive. So you are barred essentially from seeking any help from law enforcement. There's an expectation that survivors have the ability to stop their perpetrator from coming to their home, and so there are the same kind of expectations around housing that are put there around child welfare. Well, you have to keep your perp away. You have to go get a restraining order whether you want one or not. And the understanding there around safety, the understanding around risk, you know, yes, this survivor may be at risk, but they're really probably not much of a risk to anybody else in that home. And the real risk for this survivor is for them to become homeless. So giving context around what things are within that survivor's control, what things are not, what real safety risks are for other people in that apartment building or other people in that neighborhood. It's dealing with the same kind of myths and fears around domestic abuse and around what control survivors have and don't have, and the choices that are and really are not open to them that happen everywhere else that we go.
And if I can follow up with that, there's a couple things. I don't know if this is national or just in Texas, but survivors are actually able to break a lease without penalty. And that's one that fairly frequently somebody would need to step in and work with the landlord about that if the survivor was wanting to break the lease because of the abuse. And then the other piece I wanted to talk about is in educating about the dynamics of domestic violence. A part of that is focusing the attention where it needs to be, which is on the batterer behavior and the impact that has on the survivor. Because what I have found is typically the abuse is seen as an isolated incident rather than a pattern of conduct. And so being able to identify patterns or talk about the patterns and identify that coercive control that gets established in different ways that isn't always necessarily about physical violence is helpful for the court, especially around with child custody, in ways that if protections aren't put in place for the survivor around visitation, that the batterer will use that as an opportunity to continue to control the survivor. And judges, not all judges are as receptive as the civil attorneys I have worked with, but, they like the information also. They need the information. They don't have it. So I just wanted to add that piece.
Thank you. Margaret, with the civil cases that you've seen, can you talk a little bit about what areas of testimony are often needed the most? I mean, one thing that's unique about these cases as compared to criminal is that they often involve children, and so I would imagine that gives rise to specific topics. So can you just talk about what tends to come up the most?
So figuring out figuring out the custody arrangement and whether there needs to be supervised visitation or not, and why somebody may want to use a facility that will provide some safety in exchanging the children. And then I'm not sure if this is actually a part of the question, but when you asked the question you did, the immediate thing that popped into my mind was parental alienation and just how effectively it is being used in custody cases to where the survivors, the children, are being removed from the survivor. Yeah, so I actually lost my train of thought because I'm working on a case right now that is just so frustrating with that. But being able to respond to parental alienation, I think, is an important piece because it comes up quite frequently.
And
at least that's what I've found.
And can you just say, in a case where the other party's alleging parental alienation syndrome, what can an expert do to try to combat that? How can a lawyer use you to shut that stuff down?
One of the most important ways, I think, is being able to talk about trauma and the impact of trauma, and talk about the risk that the survivor has when they're making decisions of staying or leaving, and as they make these decisions, how the batterer's behavior will escalate. If somebody is providing an assessment or is looking through a lens that it's a bad relationship, they just bring out the worst in each other, then they're going to miss the impact of trauma on the survivor's behavior, which influences the decisions they make. And then the behaviors can be seen in a way that are more about alienation rather than about safety.
Kirsten, did you want to add?
No, parental alienation syndrome is kind of like a 7-year locust. It comes and goes in waves and cycles, and I think it has come back as a tactic. And in all of these cases, you just keep coming back to the issue of trauma and testifying about trauma and the impacts of trauma and how that affects people's choices. And along with the trauma is survival and talking about survival not only for self but also for children and coping skills and protective strategies. I haven't seen that, and this is one person's very limited experience. I haven't seen that attacking parental alienation from a purely here's my research versus your research has been terribly effective, as opposed to simply providing an alternative that is as credible a story on behalf of that survivor and kids as what the batterer is providing, and then kind of hoping that your version seems reasonable.
I think that's a really good point.
Yeah, I do too. So just to clarify, so in other words, you're not trying to take down the crazy world of parental alienation syndrome. You're actually just offering some explanations about why things are happening the way they are.
Yeah.
Is that okay? That makes sense.
And I think something that advocates can understand as they step into the role of an expert witness is that the expert is really being called to provide alternative explanations for behaviors that are being judged in a different way. And anybody who has worked in the domestic violence or sexual assault world really knows the behaviors that the survivor is engaging in and where it comes back to. And just being able to provide that information can be really helpful.
That makes sense. I just want to give a little context for this question. Here at the clearinghouse, when somebody calls us about a case, they might say, "Oh, I've got one of those battered women's cases," and they actually aren't necessarily sure yet what they're asking for. So I'm just wondering, Kirsten, when you get a call for somebody looking for an expert witness, what are they asking you to do initially, or what are they looking for, or what do they think they're looking for?
Some of them know, but a lot of them don't. I'm looking at the slide that was just put up. Because these are a lot of the questions that I want to work through with them as we're talking about whether or not testimony is a good thing and whether or not testimony from me is a good thing. Sometimes what they're looking for when they're asking the questions is really answers for themselves as the attorney. Mm-hmm. And it hasn't come up a whole lot yet, but a huge part, if not the bigger part, of I think what we do as expert witnesses simply to educate the attorney. So when they call and they say, "I have a problem, my person didn't cooperate with prosecution, and now we're trying to say that the partner is, the ex-spouse is too dangerous to have shared custody, and those two things don't match." They're often not asking in terms of, "Please explain that to a judge." often they're asking in terms of, would you please explain that to me because I don't get it. So partly they want to know for themselves. Partly they want to know what they can do to frame. They kind of have an idea, and they want to know, how do I frame it in my presenting the case? How do I tell the story? So they want language from me, even if they don't ever use me to testify, but I can give them a language and a structure. Sometimes I've had people call, and what they want is for me to somehow interpret for the client, either to the courts or to the attorney that's talking to me. And all of that is really separate from what might actually happen on the stand. So sometimes they know, but a lot of times they don't. A lot of times they're just trying to feel out, okay, this might help, but I'm not sure how. I can tell you what my problems are. Can you solve my problems for the case? And can you help me clarify this in my own mind? I don't know. Does that sound familiar, Margaret?
Yeah, I think those are really good points. The attorney needs to be able to grab onto something in the case, and so there's all these puzzling aspects to it, or conflicting information, so that which confuses them because they're not really sure what they can do or can't do. And the more information that we can provide and answer, as you said, answering their questions, they may not use like that information specifically, but being able to have the context will allow them to ask better questions to elicit the information that they need to elicit. And the other thing that I've had attorneys, so we'll have a discussion, and the attorney will feel better about the testimony they're going to elicit from the survivor, but then they'll ask me to testify for the judge, so that the judge can also hear that part.
Mm-hmm. I mean, one of my first questions is, what's your problem?
Mm-hmm.
Right.
So you're calling me. What's your problem? What is it that you want me to solve? And that really helps narrow things down. So, the question on the slide, what's the goal of the testimony? Framing that as what is your problem seems to help clarify that. I don't know that folks want me to prove that somebody was abused, because that's not anything I could do anyway.
Right.
But it's more about what does it do to somebody to be living in a context where they are constantly afraid and they cannot, that no choice is a good choice. What is that like, and how does it affect their behavior? Hopefully, I mean, if they're going to say, please prove that my person was abused, I'm going to say, no, I can't do that anyway.
Mm-hmm.
Right. Yeah, I agree with that.
Yeah, that seems to be a bit of a knee-jerk thing. Like, oh, it's a DV case. I need a DV person. Maybe they do, maybe they don't. So
if I can jump in, the
yeah.
other piece is sometimes an attorney will hear that there's domestic violence, and so they'll want to use battered women syndrome to explain everything, and kind of helping to untangle that piece for them can be helpful in how they approach the case and the survivor.
Makes sense. Just in this past few minutes, the idea of whether or not expert testimony is going to be helpful or is it going to backfire has come up a couple of times. So can either of you talk about, ways that you can anticipate expert testimony on domestic violence not being helpful to the survivor in that case?
Do you want to go for it? Or either one of us.
That one's, there's usually there's a set of different factors that kind of converge to where if my thought around it is that bringing in expert testimony about domestic violence muddies the water in a way that doesn't need to happen, even though domestic violence is there. What's happening in the case or in the courtroom, it doesn't really provide further information. It just provides a more I can't think of the word, but yeah, that's the times when I will talk with the attorney that perhaps bringing in an expert on domestic violence isn't necessarily the right step.
You know, like if you have a custody case and you have founded child abuse against the batterer,
right.
That's probably clear cut, and that's enough. That if you then overlay talking about domestic violence, you're more likely to turn the judge off and have them go, oh, sure, now you're just going to throw everything in there. And so if you have good enough stuff, you don't need to go there.
Yeah.
I would also just say flat out, if I'm talking to an attorney and that attorney, you know, there is a courtroom work group. They are familiar with the judges in their area. If you have a judge, there are some judges where bringing this in is simply going to immediately turn that judge off, make them rigid, turn their ears off. It's probably not a good idea.
How about cases where? Oh, go ahead.
Can I say something on that?
Yeah.
In situations like that, that's a really excellent point you brought up. It can still be helpful to talk with the attorney to help them have a better understanding. So again, so that they can elicit information in a better way.
Absolutely.
Yeah.
Well, and that's actually a really good transition to kind of the next thing that I would like to talk about, and that has come up a few times in the course of your answers, and that's just the fact that a lot of times the bulk of your job happens way before or whether or not you ever get into a courtroom, and that's the education of the attorneys. So if there's anything you haven't covered so far about how you work with attorneys to prepare them for their case and for using you, can you talk about that now?
Is it okay if I go?
Yeah.
Please.
I think it's important to realize that as an expert witness, we're working in collaboration with the attorney. So it really is a team approach. My experience has been when an attorney calls me, they actually do want me to provide information to them, and they do listen. So if you get called as an expert, just kind of owning that piece of it, you do have good, important information that can help the attorney. Whether they use you as an expert witness or not, you bring in really, really valuable information.
And Margaret, just to follow up on that before we get to Kirsten, in your experience, what is it most common for attorneys to be missing? You know, they call you, so they obviously have a sense that something's going on with domestic violence. But where do you often find the gaps are in terms of what they know and what they don't know, or you know, what kind of abuse they're tuned into and what they're not tuned into?
It really, I usually find myself talking about myths with them, that there are these myths and these biases that exist. So I'll talk with them about that piece of it. And then also just the idea that domestic violence is about physical violence, and being able to identify and lay out the coercive nature, the coercive patterns that can be established, how they can be established, how that might impact somebody and the decisions they make, and that the decisions are typically safety-based when viewed in the right context.
Kirsten?
Yeah, I sometimes even letting them know how the other party might behave. There's Lundy Bancroft has an article. It's called something like "Batterer Behavior in Custody Proceedings," and I frequently give that as, and this is what you can expect from the opposing party. And sometimes people are really happy to get that because it lets them plan through negotiations and everything. Sometimes it explains why the other party is doing some of what they're doing, and for some reason having it written on paper by someone who is supposedly an expert suddenly provides the clarity that even though their client was saying it, it didn't get heard. But anyway, sometimes I've given that kind of information and said, here's what we can predict is going to happen in this case. This is the pushback you're going to get. And I've been patted on the head, and they later came back and said, oh my gosh, you were right. Can't believe this happened, and you hit it on the nose. So even just in, because people have this idea that divorce is a noun, and divorce is actually a verb, and it's something that goes on far before and far beyond any actual hearing date for a trial. Something that looking at the behaviors all throughout this whole process. I had an attorney that contacted me. It was a dissolution, and the client had already gotten a waiver from mediation. There's a lot of places here that has mandatory mediation in dissolution cases. She had already gotten a waiver based on domestic violence, and when he was speaking to me, that came up, and he said, but you know what? We did it just because, but I'm just going to tell her to go ahead and participate anyway. And this is where you slip and slide in between expert and advocate. And the advocate hat went on and said, well, here's my concerns about that, and here's why that waiver exists. And he decided to ignore me, and it went really bad. But so there's places like that where you're giving information as well. I think it's really just, when I said the hat slips off into advocacy, you're just in a role of amplifying the survivor's voice, because sometimes it takes that third person saying the same thing that the survivor is probably telling them, but not in a language they can hear, to give them some clarity.
Go ahead.
Oh, the slide says that, especially trouble with non-physical abuse. I was just thinking of talking with someone who she was struggling understanding the why did she stay piece. And it was really clear to me, she stayed because she was present in a home where she was taking care of previous victims' children. And yeah, she stayed because she couldn't abandon those kids. She had no legal rights or authority or custody over those kids, but she felt the responsibility there, and there was a bond and connection, even though she'd only, really been present in that home for a relatively short amount of time. And it was like, this is what's going on there. And suddenly that made the whole case kind of make sense. Everything kind of clicked into place, and that was a story she could tell. So rather than here's, the story being framed as, here's this foolish person who didn't seek services or help when she could have, it was suddenly, here's this hero who put her own safety at risk to protect these children.
Excellent reframe, for sure.
Yeah. The other piece, one thing I think that we as advocates know is that leaving an abusive relationship doesn't mean the abuse ends. And when somebody understands that piece, it goes a long way toward helping explain the decisions that a survivor makes leading up to and during a separation or divorce.
Mhm. And I'm going to just, when you said earlier that sometimes you are trying to find culturally specific expertise provided to a case, that's also
Yeah.
a place where people don't necessarily have the specifics. Situations for me arises where the batter was constantly calling his partner a cat, and okay, well, you're a cat, so that doesn't seem terribly damaging. But to have the cultural context of no, within this particular cultural context, that is horrible. That is, that is incredibly demeaning, because it talks about her sexual chastity and her, it was an entirely different situation that wasn't, the impact wasn't translating for the attorney, and therefore the attorney couldn't possibly translate it for the court if they weren't getting it themselves. So, anyway.
Before we get into some more specific stuff about custody cases and other kinds of civil cases, let's have a chat box moment, if we could, for all the participants. For those of you who have testified as an expert witness, can you just briefly type in the chat box cross-examination challenges that you've had to confront or address? And there's not a finite list of these things, but some examples could be like, have you been crossed about the survivor's mental health history or her non-cooperation in cases, or the fact that she didn't call law enforcement, or parental alienation syndrome, those kinds of things? Just can you quickly type it in the chat box so we can see what you've been challenged on? We'll just give you a second to do that. Great, thank you so much, everybody. That'll kind of inform, what we talk about when we're giving some specifics about different kinds of testimony and different kinds of cases.
Seeing the stuff there about the victim's use of force, that's actually huge. So I'm glad that came up a couple times in the chat box there, being able to explain that, actually, when you're being hurt, you try all kinds of strategies for safety, and one of them may include using force.
And I think, I tend to only think of survivors' use of force in the criminal context, but obviously it's got to come up in civil cases as well. Do you see it in custody cases and that kind of thing, Kirsten or Margaret?
Absolutely, that's the preemptive strike. Oh yeah, I might have hurt her, but look what she's done to me. See, it's just mutual, and therefore it's just both is washed out, and so we can just eliminate that as an issue, because see, she's just as bad as me. So very much so, and seeing perps that are willing to admit to smaller things, so that it seems like they're being honest and credible and forthcoming and regretful about what they may have done, and then because the victim then saying, but look what the victim did. They did this other thing, and look, they're not being regretful about it. They're not being whatever. They're not being forthcoming. See, they're actually worse. They're the perp.
Yeah, and the other that brought to mind just like having a better understanding of strangulation and what could happen during that, because in my work with survivors, there will be times where they're identifying, that they really hurt their partner, they really scratched them up, or they hit them with something, and in talking with them about the events around that, and finding out that a strangulation had occurred, or that the injuries happened either during the strangulation or a strangulation had happened before, and they were the situation was arising and it was very similar to the previous one, and that they would have that preemptive behavior to protect themselves. But just being able to provide